How does a DMV hearing work in New York? After a DWI arrest in New York, most people focus on the criminal case without realizing a second, equally consequential proceeding is already running on a separate track. The Department of Motor Vehicles hearing does not decide guilt or innocence, but it does decide whether you keep your right to drive. These two proceedings operate independently of each other, with different decision makers, different rules of evidence, and entirely different consequences. The most common type of DMV hearing after a DWI arrest is the chemical test refusal hearing, governed by New York Vehicle and Traffic Law Section 1194. Under New York law, this hearing must be scheduled within 15 days of your court arraignment, and skipping it can cost you your license by default. At your arraignment, the criminal court judge temporarily suspends your license pending that DMV refusal hearing, making early action critical. An administrative law judge, known as an ALJ, presides over the hearing through the DMV's Safety and Business Hearings Bureau and rules solely on your license status. The ALJ is not bound by the strict evidentiary rules used in criminal trials, which means the hearing can move faster and consider a broader range of documents. At a chemical test refusal hearing, the ALJ focuses on 4 key questions: whether the traffic stop was lawful, whether there was reason to believe you were driving while intoxicated, whether you were clearly warned that refusing carried consequences, and whether you in fact refused. The arresting officer testifies about the stop and the events that followed, while you and your attorney have the opportunity to cross-examine that officer and present your own evidence. The DMV reviews the police report, the chemical test refusal report, any breath test records, field sobriety testing notes, and the officer's live testimony about the warnings given. If the paperwork is incomplete, inconsistent, or contradicts the officer's testimony, that can meaningfully affect the outcome of the hearing in your favor. If the ALJ finds the refusal was proven, your license faces a mandatory minimum 1-year revocation and a $500 civil penalty, with no eligibility for a hardship or conditional driving privilege. If the DMV fails to meet its burden of proof, the case is dismissed and your driving privileges are fully restored. Randall F. Inniss of the Inniss firm, PLLC, served as a New York State Trooper for more than 22 years before practicing law for over 25 years, giving him a rare perspective on how prosecution evidence is built and how to challenge it. He examines traffic stops, field sobriety tests, and chemical test procedures from both investigative and defense angles. Bringing that dual experience to every DMV and criminal case he handles, you have the right to be represented by an attorney at the hearing, the right to question the arresting officer, and the right to raise objections against the accuracy of official documents. Early preparation, thorough review of the paperwork, and knowing precisely which questions to ask are what separate a strong defense from a default license revocation. Call the Inniss firm, PLLC, at 845-470-4236, located at 280 NY 211 Suite 203, Middletown, New York 10940, to schedule your consultation and build a clear plan for both your DMV hearing and your criminal case.